All right. Welcome everybody to the University of New Mexico Law and Mental Health Didactic Series. This series is hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. We're glad you're all here joining us today. My name is Julie Bravko. I'm an assistant clinical professor in the Department of Psychiatry and Behavioral Sciences. Next week, we have Mr. Clarence Sundrum presenting court-ordered reform and systems change. So make sure you join us for that. For our talk today, please ask your questions in the Q&A. Anytime you feel comfortable, just know we're not going to get to them till the end. For those of you who are here for CEs, but can't stay longer than the hour, just know you do have to stay for the full hour. You don't have to stay longer than that. We may go over a little bit to answer questions, but I will let you know when that hour has passed. For those of you who need CMEs, those are the medical CEs, go to the sign in the chat now. For those of you who are here for the mental health or APA CEs, the last 5 minutes of the talk today, we will post a link to a survey. Please click on that link, complete the survey, make sure you print it, save a copy, screenshot it, whatever you need to do. We don't save copies of it and we don't email copies out. Last week, we did try something a little different. We emailed the link out, but we are going back to posting it in the chat the last 5 minutes. So please make sure you get that today. All right. Oh, and as for the recording and the PowerPoint slides, we will be sending those out or uploading them into our system in about a week. So make sure you look for that. And if a week has passed, you still can't find it, then go ahead and reach out to us. So I'd like to introduce you to all our speaker for today, Dr. Mike Vitacco. Dr. Vitacco is a board certified forensic psychologist who's published over 100 times in the area of psychology and the law. Specifically, his research has focused on the treatment and prevention of violence among individuals found not criminally responsible and conditionally released back to the community, evaluating how forensic psychologists can appropriately utilize social media information in their practice, detecting atypical response styles in forensic evaluations, the legal applications of psychopathy, and evaluating and treating violence potential with individuals housed in forensic inpatient hospitals. As part of his work on conditional release, Dr. Vitacco has partnered with multiple states to evaluate conditional release effectiveness with individuals with serious and persistent mental illness. Dr. Vitacco, thank you for coming back and being willing to present with us again, or for us again. As always, I'm honored to welcome you, and I want you to know that we are so grateful for your time and expertise today, and I'm now going to turn it over to you.
Thanks, Julie. As always, I appreciate your introductions. Alex and I were just talking last week that your introductions really are the best, and those should be recorded and sent out to folks. But today I'm going to be talking a little bit about the basics of conducting conditional release evaluations. And in addition to the conditional release evaluations, I'm going to talk about programming and some key issues and key factors to keep individuals with serious and persistent mental illness who've been found not guilty by reason of insanity safe, and to keep the public safe. I have no really disclosures to speak of. Will be a book coming out probably within the next year on conditional release evaluations, but I can't even talk about that now because it's nowhere ready. It's just in the starting phase. The learning objectives today is I'm going to talk a little bit about the complexities of conditional release evaluations. And really a lot of information discussing risk assessments and various aspects of kind of how to think about these things, and specifically who stays in, who gets out, and really how that works. I want to talk about some of the effectiveness of conditional release programs in some of the states we've partnered with that really have looked at the effectiveness of such programs, and really want to talk about kind of what about these programs works and how to best implement that, because in fairness, there's just a lot of right ways to do this. So I think this talk will cover a little bit of each of these things. I don't think I'm going to go the full hour. I think there'll be plenty of time for questions and answers, but we'll kind of see how this goes. But regardless, I'll be done talking around 2 o'clock. Okay. This is just one of my favorite quotes, and I think it applies so well to conditional release programs. And you guys can read it here, but often people think of these things as very straightforward and simple, and I think ultimately they're not any of these things. They're complex problems. There's complex issues, and what I'm going to talk in the next couple of slides is really how political these things can be. And of course, I'm going to use everyone's favorite example, the most famous conditional release individual out there, who is John Hinckley, who recently had his unconditional release approved. And the judge in this case noted, and I think very accurately, that very few patients at St. Elizabeth Hospital have been studied more thoroughly than John Hinckley.
Hey, Dr. Vitacco, real quick.
Are my slides not advancing?
Your slides are not advancing, so let's just
are they advancing now?
There we go. Yeah, looks
Okay.
Good. So you can go right to the Hinckley slide.
Yeah, there we go. All right.
Perfect.
I saw that, and I was wondering if that was happening. Thanks, Alex. So the judge in this case again said that very few patients at St. Elizabeth Hospital have been studied more thoroughly than John Hinckley. The judge also indicated in this, which I thought was very interesting, that if he had not attempted to kill the president, he probably would have been out already. And that is probably factually true, but of course, the issue with that is he did attempt to try to kill a president, so he did remain in for a long time. The question I'd like to propose before my next slide is, what are the first things you would do after getting released from conditional release? And of course, the first thing to do would be to tweet. He tweeted immediately after 41 years, 2 months and 15 days, freedom at last. And then he went and was going to do a concert tour. He had several venues planned. Now, depending on your viewpoint, and I honestly don't have one here, several of these venues actually canceled his redemption tour because of concerns about safety. But if you guys are not aware, John Hinckley is a noted musician. So he was planning on taking the show on the road. He had a couple of venues planned in New York on various things. So we'll kind of see how that plays out. It could be coming to a city near you very, very quickly here. But the bottom line is these are kind of his plans as he's finally obtained his ability to kind of go wherever he wants and do whatever he needs to do. But if you look at John Hinckley's conditional release plan, and you can actually find this online, it really encompasses many, many things that most conditional release plans have. Of course, given the high profile nature of him, I think the plan went on for almost 100 pages in a court order. And at least in the state I practice in Georgia predominantly, these conditional release plans do not, they're much shorter than that, but his kind of had it all. There's two cases that are talked about very, very frequently when we talk about conditional release. Jones and Fucha. I think in fairness to them, they're not a lot of help in how states kind of do things. But we're going to talk about them and talk about some of the basics that they have, because ultimately they do provide at least an interesting framework for how we consider individuals ready for conditional release and those who should be discharged from the hospital. The other things I think that I'll talk about kind of at the end of this kind of trio of slides is how the defense and the prosecution, how the adversarial system sort of focuses on each of these very, very differently, because they kind of take different approaches. And the first case is Jones, and Jones talked about what, Jones was kind of found NGRI in a relatively minor crime. And Jones allows the government, the state in this case, or the federal government, to hospitalize individuals who are found not guilty by reason of insanity. And they can confine them to a mental health institution till he has either regained his sanity or is no longer a danger to himself or society. And the idea here was that the justices in Jones sort of believed that they were not concerned about idiosyncratic concerns, because an individual found not guilty by reason of insanity or idiosyncratic behavior was because there was an assumption of criminal behavior. So this really kind of gave the government a wide power to put individuals in forensic facilities, state hospitals, or various other supervision areas to prevent future criminal behavior. And I think what's really important here, and we don't have time to go state by state, but every state has kind of even taken this information and has done it very, very differently. For example, I used to work in the state of Wisconsin, and every individual who was found not guilty by reason of insanity received a quote unquote sentence. Now, it was a sentence to the state hospital, and they could get out early, but it did sort of put some conditions on the state's ability to keep someone in a forensic institution without appropriate checks and balances. I've known from anecdotal stories and talking to other clinicians, every state doesn't have such a program, so that some states, an individual can remain within the state forensic facility or forensic hospital for the rest of their life if they're still viewed as mentally ill and dangerous. So it is these sort of things that states have done sort of very, very differently. On the opposite side of that is Fucha, right? And Mr. Fucha was committed to a Louisiana hospital after finding of NGRI on charges of burglary and illegal discharge of a firearm. And ultimately, his release was ordered because he was found that he was no longer mentally ill and cannot remain committed. And what the court did in this case is they sort of echoed Jackson v. Indiana in 1972, where they just talked about there has to be sort of a reason for the commitment based on a continued commitment based on what they were initially committed for. So in Fucha's case, right, he was, given the fact that he was committed due to mental illness and dangerousness, that had to remain, and that the mental illness, primarily mental illness, went away. He was no longer, they were no longer able to keep him. Again, though, what really is interesting about this situation is that every state has sort of done this differently, and that many states have found reasons to maintain individuals within state hospitals for things such as a personality disorder, or even there's been a couple of cases where alcohol issues have sort of kept people within state hospitals. And it's really interesting how states have been given authority to do this, and each state has kind of tweaked it their own way. I don't think this should come as any surprise, but prosecutors, when these cases go before you have to testify, really want to focus on the individual's initial crime, focus on potential dangerousness, whereas defense attorneys want to appropriately focus on the remittance of mental illness and the fact that there's no longer a link between mental illness and dangerousness. What is really interesting, and I find very helpful, is that when I do these types of evaluations and when I've asked, what do you call to testify, I think it does both sides really a great service to focus on kind of where they were in the process when they first came into the hospital or came under conditional release to where they are now, the improvements that they've made. We'll talk a lot about this kind of going forward with various assessment techniques and kind of think about the best way to go about this. But I think it goes without saying that courts want to hear the fact that this individual has done well in treatment and no longer presents a danger. And I'll show you some research later that talks about that conditional release evaluators, that the primary thing they do focus on, and rightfully so, is the fact that this individual, what is their current level of dangerousness? How are they presenting now, and what's kind of going on with them? And I think that just makes a lot of sense. So this is, I just took this right from the federal code, and this is the outlines of conditions of release in the federal system. And they go through a whole host of things. And many of these things we're not going to really talk about today in any great detail. But they make a lot of sense. The one that we are going to talk about is discharge. But I mean, importantly, they go through a very, very similar process where there is a determination whether there continues to be a mental illness. There is a report filed with the court with the hearing. And the burden of proof too is also very interesting because in many states, the burden of proof changes that the individual who is committed has to prove that they are no longer dangerous. Again, but it makes a lot of sense. And then the federal government also talks about revocation and how that can work. There's also just been some great case law about who can be revoked and why. And there's, again, a whole host of decisions that have, and many times, depending on the jurisdiction that you're in, been quite different. For example, on some jurisdictions, the mere breaking of a conditional release rule is not enough. In the state of Georgia, for example, often that would be enough. If, for example, it's an alcohol-related incident to tip the scales in favor of them being rehospitalized. But again, and I think that also depends on who your judge is and various things. But let's talk a little bit about 4243 and talk a little bit about discharge. But here it's very, very clearly that they want to make sure in really making this quite short and sweet and simple, that any release would no longer create a substantial risk of bodily injury. And also no risk to property. So the federal system really focuses on those two aspects to make sure that someone is prepared for conditional release. And again, it's really kind of getting at those two issues. But the second part of this is also really interesting. And again, it's focusing on bodily injury and property damage. But they also want to make sure that this conditional release program, the plan that's in place, is going to mitigate these issues of dangerousness and mental illness. So for example, we kind of turn back to Hinckley a little bit. His initial conditional release plan allowed and actually mandated things like music therapy, that he could play his music under, again, it was highly regimented, but it really kind of went about these things. And I think, often we tend to focus a lot on medications and various things, but I think it's really imperative that when we talk about such sort of conditional release plans, we really kind of consider a whole host of factors that have been shown to decrease risk, while still focusing on the primary issue of decreased violence. I went to a court hearing once where the psychologist was actually kind of getting into an argument with the prosecutor about the importance of community dangerousness, and it could have ended very differently if they would have simply said, and the primary thing we focus on is to make sure that this person is not a risk for violence. It would have ended the entire discussion. But I think, once we focus on that, to make sure that doesn't happen, there's a slew of things we should be thinking about that are really helpful at minimizing someone's risk for violence towards themselves, towards others, and to property. This is really kind of gets into more of that. But again, one thing that's really important as I look at part B here is that the specifics of the plan, it's going to sound highly redundant here, but are specific. So when we talk about conditional release plans, when we're going to put these individuals back into the community after they've been found NGRI, after some treatment, and that treatment doesn't necessarily have to take place in a hospital. I'll talk a little about that in a little bit. But we are as specific as possible about what that psychiatric or psychological care or treatment is going to look like. So for example, if that involves work therapy, we're very specific about what that looks like. If it involves various groups or other things, we're very specific about what that looks like. Because there's actually some case law that talks about, if it necessarily isn't in the conditional release plan, determining whether it is a rule violation or whether this person is decompensating or various issues becomes a lot more difficult. And some courts, based on civil liberty issues, have been very, very reluctant to bring someone back into the hospital. And I think, that sort of sets the standard that we should be very comprehensive and very clear in these conditional release plans and programs that we submit to the court about what is needed and what that's going to look like. Okay, so these are the outcomes that we monitor on conditional release. That in the research that I'm going to be talking about coming up, what we look at as outcome variables. But the first one is, do they come back? Do they make it out, or is there a return to the hospital? And then, are there rule violations? But the fact is, for example, that is often a very, very poor metric for success on conditional release, because really for two reasons. One is rule violations are often go unreported. And secondly is that I think various individuals who are important in this system, judges, probation officers, conditional release community case managers, view rule violations very, very differently. And then the third one that is a little bit easier to measure, just because it's either a yes or no, is that has there been a new rule violation? And then depending on the severity of the new criminal offense, the person will either be rearrested or automatically returned to the forensic hospital. Actually, in some jurisdictions, sometimes both. And of course, there's always an emphasis on violent offenses. So any sort of violent offenses is viewed, any sort of occurrence of a violent offense is viewed very, very differently. And what I have found in talking with stakeholders about these issues is that a violent offense or a new criminal offense by someone who has found NGRI is often viewed through a very different lens than from someone who has been paroled from prison. And I think often unfortunate, a much more negative lens. And I think that's just one of the biases that some of our folks that we work with have to overcome, because their behavior is viewed very, very differently than someone in a same situation from a prison. And then my last point here is sometimes the outcomes are precise, that we can talk about, whether there's been a return to a hospital, whether there's been a new criminal violations, but I think that their pathways are very, very far from precise. And the primary thing that just kind of illustrates that for me, and I hope this resonates somewhat for you, is that often, depending on even where you live within the same state, rule violations and different things are viewed quite differently. Some of it might be, do you have a conservative judge? Do you have a more liberal judge? And how they view the individual before them, I think often has a very huge sort of puts a direction on that individual that it would be better if it wasn't there. But I think that's the reality of it. But I think these things, from a imprecise pathways, I think these things are very sort of important to note. And frankly, there hasn't been enough research on this, and it's an area that I'm very interested in. If anyone wants to partner, here's my one plug. Shoot me an email. We'd be happy to talk about these issues. Okay. One thing I think we have found through our research is that insanity acquittees are both unique, but they're also highly consistent throughout the United States. And what do I mean by that? Well, first of all, there are a group of individuals who have serious and significant mental diseases, often in the psychotic spectrum, but they're very diagnostically heterogeneous. But we know that their mental illness are so significantly severe that if the NGRI report and evaluation is done right, leading them to be found that they have very functional impairment in their ability to sort of comport with reality, their ability to differentiate right from wrong, and all sorts of important things like that. But as a group, they have a very high level of violent crimes. Now, obviously, I'm not about to wade into the whole debate about mental illness and violence, because I don't think this actually speaks to that debate at all. But what I think it talks about is that as a group, individuals who commit certain levels of crime with significant mental illness are more likely to be found insane and more likely to plead NGRI than other individuals. For example, it doesn't make a lot of sense for a petty theft, even if that individual has significant mental illness, often to plead that because they're going to spend more time in the system than they otherwise would. This is just an example of 5 states that each of these is a published article, but it sort of looks at this percent of violent offenses within each state sample. And again, it's pretty consistent. The Virginia sample was a little bit more than the rest of them, but the other ones are pretty much right, hovering around 50%. So I think that really speaks to the fact that attorneys in those jurisdictions are doing a pretty good job at sort of picking and chooses cases that are worthy of that. The one thing I'll just want to highlight something about Virginia and also Wisconsin that's really sort of interesting is that both of those have something called direct court release, which means that theoretically, and I'll go a step beyond theoretically, it absolutely does happen that certain individuals after their initial period have to spend no additional time in the state hospital. And they can be discharged to the community with a conditional release plan as soon as that's been approved and very shortly after they're being found not guilty by reason of insanity. Why is that important? Well, it's important because it really sets a pathway for these individuals to return to the community at a much more rapid pace. Now, in both of those states, we did very simple analyses that looked at individuals with a direct court release versus those with a lengthier period of hospitalization. And we found no differences in violence rates, which, by the way, were especially low anyways, but new crimes or return to the hospitals. Now, I think it is probably safe to say that those individuals who have direct court release are often not your high-profile offenders, not your high-profile individuals who have committed significant offenses. But regardless, they still had significant impairment that they did extremely well in the community. And I think that's really important to know that there are just a host of things we might be able to do differently that could decrease bed space and financial pressure and a lot of issues that states are currently undergoing and are making changes to the process of hospitalizations. So I spoke on this a little bit already. But if you look at the hypothesis for the findings of violence and dangerousness among the sample, I think the only hypothesis that really makes sense is it's really a combination of this is a violent group, but so designated because of a host of legal and clinical factors. So it's not just, again, any relationship between mental illness and violence. It's really the fact that they're so mentally ill, and more so in the fact that they have attorneys who are correctly referring these individuals for forensic examinations to try to get them the appropriate relief and the treatment that they so desperately need. It just makes a host of a lot of sense that this group would be more violent. But then, as I'll show you in the next several slides, they're not more dangerous once they are returned to the community. So the fact that treatment and monitoring and all these things works very well, which hopefully you'll see in a bit here. So this is a study authored by Neil Goensmith, and this is I was privileged enough to be beyond the study, but Neil and his team did just a great job here. And it's a simple study that has really kind of, I think, fun results. And they looked at 89 evaluators from 9 states. What they found out at the time, and this is from 2014, so it's a little dated. And Neil, if you're listening, we should probably take a look at this again. But only under half of the evaluators received specialized training on how to conduct conditional release evaluations. So often these folks were just kind of, if you will, thrown into the mix. And I think now with the propagation of in postdoctoral programs and violence risk assessment and hopefully seminars like this, and I know a lot of folks are focusing on these risk assessments in educational clinical settings. Hopefully this will increase. But there was 2 parts of the survey. One just looked at factors that they were considered, and then they looked at just broader factors related to success and failure on conditional release. But in 2014, the results were I think safe to say a little bit concerning from a scientific standpoint, beyond the fact that less than half of the evaluators receive specialized training. As I'll show you in this deeper dive here, there's more concerns than just that. So I think this is important, and this is a kudos to these evaluators. It was past violence had the largest score in the survey. Of course, which is something that should be considered, past violence often does not decide who is actually in best preparation and best ready to be released. So they're keeping folks there who may be ready to go, but who may have a high profile offense. The second one was adherence to medication. So again, folks that are in the hospital who are doing well, who are clinically stable, hopefully, the medications are working. But beyond that, the rest of the factors were just a bunch of things that at times didn't make a lot of sense. And they were not very systematic in kind of making determinations of who should be released and who wasn't. So this was good. About 60% of evaluators use a forensic assessment instrument to aid in determining readiness for release. And hopefully 38, that was a risk assessment instrument. Interesting, 7 used a malingering instrument. So, I didn't really, and I don't think, we kind of talked about this, but it doesn't make a lot of sense when these folks probably would be more defensive than anything. But I think the concern was that these folks were doing their basic forensic evaluation, which included a type of response style instrument, and then employing that to conditional release evaluations. Again, what we're looking at here just wasn't very systematic in really sort of focusing on those individuals, who were ready for release. So despite the fact that I think it's good that almost 60% were using a forensic assessment instrument and 38 used a risk assessment instrument, that means the vast majority of individuals were kind of just relying on their own clinical judgment to make a determination of who should be released and who was ready for release in developing their risk assessment. This, of course, is legitimately concerning. And again, we should probably take a look at, again, redoing this study, because I think the results might be different. Okay. Here's some just basic concerns on conditional release that those are in the system, I hope you at least can see that these could happen. But the biggest concern that I had is on non-data driven recommendations. So these are recommendations that are made that somebody has to kind of go through, follow through as part of their treatment plan, but ultimately are not scientifically based or even individually based. And if you know the work of Dan Murray and various things on risk assessment, some of the work that they did on adversarial allegiance, which is just absolutely fantastic, is you can say the differences in recommendations often are who hired the expert. And this is a real concern. And Dan's study, that really terrific study, looked at risk assessment data. But it clearly is a difference when the factor of who is hiring you, what side you're representing, becomes the predominant factor of release. And this plays out in a number of ways, but it also plays out, and I think, unfortunately, is that a single data point, like, for example, a fight within the institution, is used as a reason to keep someone in a hospital without looking at the entire context of that one incident. And it becomes an issue. On the flip side, I think bed pressure can also contribute to these issues of releasing individuals who are not ready. And I know in a lot of states right now are experiencing long waiting lists. I think from the sound of it, COVID has not helped any of this. But I also know that there's, anecdotally, I've heard discussion of, well, we need to release this number of people. This number of individuals need to be discharged. Of course, the problem is when you're dealing with that, you're putting on a sort of a false ceiling of how many people you got to get out, and you're not really focusing on the individuals who may or may not be ready for discharge. But I certainly think that is something that warrants much more kind of discussion of how to maybe best handle these. And one of the ways I know many states are doing this now are sort of halfway houses, even halfway houses on the state hospital facility. And in my experience, this is just a terrific way to kind of go about managing both your kind of your bed crunch issue, as well as giving individuals an opportunity for a sort of semi-release while still providing them the appropriate supervision and medication management that they need, especially in borderline cases. And in borderline cases, as I'll show you in a little bit, are very, very critical. And when they happen, I think become problematic. And these are factors that probably need to be considered much more. We know that individuals with substance abuse histories and various things related to drug and alcohol use clearly are an issue, both because they lead to mental health decompensation, but like, for example, many substances now are significantly related to the commission of violence. I was doing a risk assessment about 4 years ago. I was meeting with the individual as a hospital stay. We're talking about kind of his plan on discharge, and he made no, he made no joke about it. The first thing he was going to do when he got out was he wanted to go drink alcohol. The second thing is stable housing. And I think most states right now are doing a pretty good job about that from what I understand from the conditional release literature, but bringing these individuals into a dynamic, if you will, environment where they receive treatment and medications. I worked with a case once where a high profile murder case, that individual, by all accounts, was highly psychotic at the time and remained pretty psychotic, but was finally deemed appropriate for release and went to a great housing environment. I was there about 1.5 years and doing incredibly well and really hitting all the marks that you'd want from this type of individual with this type of history. And then unfortunately that group home moved him to a different group home. They viewed he was doing so well. And he went to a place where he basically just smoked cigarettes and then provided no real treatment. And unfortunately, he decompensated, highly decompensated, and spent the next several years in the hospital. And I don't know if he's still there, but it was really a backslide. But that just goes to show you, although anecdotal, I think the research bears that out, how important stable housing is. Intensive case management, make sure these folks get to what they need, get their treatment, get their medications, and then continuity of treatment. I think is often not talked about, but if something's working in the hospital, if something is going very well in the hospital, we should try as much as we can to sort of replicate those type of treatment conditions in the community, whether it's a specialized group or something that seems to be working. Look at this individual and see if that type of treatment cannot be replicated in the community. All right, I talked about borderline cases. And again, this is from some of Neil's work, Neil Goen-Smith. But this looks at individuals for conditional release and just the fact that the level of agreement and disagreement in these cases is very high. And if you look back at our earlier study from 2014, it makes complete sense that there's disagreement because we have not decided on what factors are important when we make the recommendation to the judge or to the psychiatric review board that these folks are ready to go. But just looking at the level of disagreement here shows just very, very strongly how maybe difficult these decisions are. So in those borderline cases, we're looking at, and I think these data from Neil came out of Hawaii. They looked at these 43 cases these folks who were released on conditional release. And in 29 of the cases, all 3 evaluators recommended a release. So that was positive. But in 14 of these cases, the evaluators disagreed on who should be discharged. There was a split. So you're looking at multiple evaluations and not an agreement. What they found here, what I'm talking about, is that when there was a disagreement, when the evaluators were not on the same page recommending released or not, these individuals were much more likely to be rehospitalized. They had a significantly better, higher level of rehospitalization. So what this is really saying, there in these cases, if we're not looking at the right factors, it places some individuals likely more at risk for rehospitalization once they are discharged. So I think kind of what we learn here is that there's not necessarily a lot of agreement per se on what looks like a perfect candidate for release, and I think that makes sense. But I think again, it really also goes to how we view and how we incorporate various data points into our conditional release evaluations. And again, we can wholly focus on the fact that this individual has been here for 3 years, has been involved in one significant fight, without really kind of looking at the fact that on every other day, they did pretty well. Some of my colleagues and I used to joke, and maybe I don't think we were all that joking, if we're being honest, that if we were in the state hospital, we weren't sure how many fights we would have in that time frame, because close quarters, you spend a lot of time with these individuals. It's not often like, prison where you can kind of get away, at least in many of the hospitals I have viewed and gone through. The old way of hospitalization put together a lot of people. Now, as hospitals have been redesigned and redeveloped, and there's much more chance to kind of get out and work and do various things. But yet many hospitals haven't experienced that yet, because that's expensive. But again, there seems to be this lack of guidance on how that works. But there's still a lot of things from this study that we don't know. And one thing I would like to focus on is the disagreement, right? We don't know really what led to the disagreement, and we don't know if these were close calls to begin with. So maybe they weren't completely ready, or their symptoms weren't completely remitted, or there was still some level of dangerousness. We don't know, again, about the judicial decision-making in these cases. There's a whole host of factors that could, again, lead to someone being revoked. That this study, and again, this isn't a criticism of the study, it's just facts that we would need to sort of look at each of these cases individually to really kind of determine what happened. Okay. One of the things we need to do, and I'm going to talk about the HCR20 now and some various risk assessment data, is that we need to kind of look at what these things look like. What do conditional release plans look like? What do these reports look like? What should we be doing? But one thing that I'm going to focus on is the idea of we need to continue to focus on dynamic factors. And I'm going to present some ideas here in a little bit of a different way after I run through the HCR20 here. But I think it's really important, if you will, to say we get dynamic about looking at dynamic risk factors. Because often what I have seen done is that we will look at dynamic risk factors 1 or 2 times while they're in the hospital, and then that's it. But ultimately, if these things are changeable and can change relatively quickly, we need to be a little bit more dynamic about our view of these variables. But like most studies, the HCR20 volume 3 is really kind of the way to go. I have slides on the items, but I'm going to skip these slides because I know you guys know this information, and it doesn't really talk much about things. But I will talk a little bit about a few studies that have looked at the HCR20 and various versions of this, and I want to talk about who gets out. So what do these individuals look like who get out? But Calvadou in 2018, again, it's these clinical and risk management factors were related to discharge. So this kind of gets back into the conditional release study. It's not the fact that they had a previous violent offense or anything else. It's really the fact that their current clinical state, and they're sort of, as we look out into the future, that they're going to be relatively stable. We had the right plan for them. That's who got out in that study. In Georgia, we found only the risk management factors predicted outcome related to release. A study published in 2016 that it was only those factors from the risk management that kind of looked at and predicted those individuals who were ready and deemed appropriate for discharge and agreed to by the court. Rebecca Kastner and I was, again, lucky to be part of this study. I appreciate Rebecca's work on all this. We looked at 331 individuals from Minnesota. This is a 2022 study, and clinical and risk factors, again, predicted release from Minnesota hospitals. So again, it's these dynamic variables that Becca found related to those individuals who were ready for release. I do want to point out, not all those individuals were NGRI, and we'll talk a little bit more about that in a second. And then Gina Muir, and we have this study right now in preparation. But again, now this is a completely different state, completely different sample, found that again, it's these dynamic variables that predicted release, that those individuals who are now clinically stable are prepared for release. So this is what I like about these data is that they come from various differing states, blue states, red states, purple states, various things like that, and you get the fact that these individuals who come to the hospital do well. All in all, the same factors predict release in system after system after system. Oops, that was fast. All right. Again, so I'll just report to the study that that Rebecca and I just published the last couple months ago. We had 22% of patients return to a secure setting over a 15-year period, but most of those individuals returned because of rule violations. So the majority of them stay out. What is notable is that if you look at the Oregon data, the data from Georgia, the data from Virginia, all those states found the same thing, a very, very low level of violent behavior once these individuals are returned to the community. And of course, what's most notable about that is the fact that over half of these individuals came to the facility and were found not guilty by reason of insanity, relevant to at least one violent charge. So this is not what you would call a typical low risk group. But again, we're finding more and more that these individuals with the appropriate treatment do extremely, extremely well. Okay. So again, this is kind of summarizing all that information. I want to highlight the Oregon, less than 2% with violent recidivism. What was really interesting when we did that research study, there was an article that came out from someone in a sort of Oregon journal talking about just all the problems these folks are having on conditional release and the high level of violence. And someone actually wrote me and I said, well, I don't know where they got their data because we just looked at the official data. And of course, like 3 months later, there was a revision to that article that ended up on probably a different page and what have you. But this was kind of left within the general public who are opposed to the insanity defense to begin with, and yet have these, again, likely because often these preconceived ideas about these individuals who are going to be so dangerous and so violent. But again, the overall data suggests something very, very different. All right. So this is one of my favorite studies is a study by Penny et al. In 2016. So what these folks did is, and just really just terrific work, is they looked at changes in dynamic variables over time. So they looked at dynamic variables very, very regularly in these individuals on conditional release. And not a surprise that as the dynamic risk factors, as they continue to go up, as there was a change in those from when they were discharged, these individuals were more likely to be violent and also return to the hospital. So, I think one of the things that is so imperative about this is that our violence risk assessment should not just stop upon discharge. They should continue. And I think it's an important variable to track. And I know most folks I talked about this don't view a return to the hospital as a quote unquote failure, in as much as often it needs to be done to kind of, make things right. So if we can prevent an incident from happening or a new crime from happening, we are in much, much better shape through this. And I think the getting dynamic about dynamic variables is one way to do it. So we make them not a one-time assessment. This slide can be summed up in one word: does supervision matter? The answer is yes. We know that individuals is once there is a change in supervision status, they are more likely, as you decrease supervision, they are more likely to return to the hospital and or have a return of criminal behavior. So it really shows, and I think that's why individuals do so well, is that through supervision and management, really are effective at kind of minimizing some of these issues our folks who have been found NGRI previously have. Okay. So some I've already spoke about. You must have appropriate community-based placements, and you must have appropriate community-based supervision. And I think how you go about doing that is very, very different based on state. But I want to just run through 5 various models. But I want to talk about that when you look at who does the best, there's got to be appropriate follow-up, there's got to be appropriate accountability, there's got to be alcohol and drug treatment must be available. You must have treatment access and flexibility. So, if someone needs to change appointments or they have a work schedule, to kind of be flexible with that is really will do very well to kind of keep them in the community, and they must have access to crisis management. So, there's mental health court division, and this is really a great judiciary and community collaboration. Involves a stakeholder participation and encouragement and consequences of problematic behaviors, including, obviously up to a return to a secure facility, but really a very good approach for dealing with some of our individuals. Risk need responsivity model, and this really just talks about that psychiatric services in and of themselves are not sufficient to reduce criminal behavior in justice involved individuals with mental illness. And by the way, that includes our NGRI individuals who we know have serious and profound mental illnesses. But the psychiatric services are a great first step. But I think when we view the data from that lens, it really shows that they need to have much more, like jobs and safe housing and access to crisis services and AODA treatment. But all these things I think really work well to kind of go through and work very well with an R&R model. One thing we found when we looked at a Maryland study we published was that housing was so critical. And what was interesting about this is we found that individuals who went home to live with their families did much worse. And I think, part of the reason for that is that these are adult individuals who need kind of their own placements and their own dealings, and we want to encourage families to be very involved with them. But I also think it becomes a problem when they're living at home. You have mom and dad often act as the caretaker to say, did you take your medications? Did you do this? Did you do this? And often that becomes a problem in and of itself. So that really speaks to the need to have appropriate group homes and appropriate placements available for our individuals. I know Louisiana does some of the forensic assertive community treatment, but this is really kind of bringing an approach from that started in Wisconsin in the early 70s and bringing this to bear with our forensic patients. But it's really providing them just significant support and significant community resources. And the data, again, bear out that these individuals under forensic assertive community treatment do extremely well. Often partnered with local mental health clinics where they can get their medications and not go too far. They have significant case management services to ensure that they get to their appointments, maybe get them shopping to get food if they need to do. But it's a really sort of comprehensive and wraparound assessment plan that I think works very well. And then approach that I actually really like. It's a combination of community support, like the forensic assertive community support, but also a probation officer. And kind of how I view this is that the CSP sort of provides them all the services that they need to go and are very supportive and are very, kind of there for them as our folks as they're needed. And the probation officer is kind of the fire that makes sure they get the services and have that kind of hammer if needed to say, listen, hey, you got to do this or there's consequences. And it takes some of the pressure off the community support programs to do that. And then there's informed supervision. And this is really making sure that our probation officers and community support folks have the appropriate type of supervision, the appropriate amount of training to deal with some of our folks. And we want, and I think it works much better when we have higher levels of trust and built-ins from some of their stakeholders, including some of our clients, some of our individuals who've been found NGRI, to build that appropriate and positive sort of release plan and folks in their life that they can focus on. All right, so I have two more slides, and then I'll be open for question and answer period. But I think we've found that conditional release is effective for individuals found NGRI. I really want to focus on dynamic variables, but ongoing assessment with our individuals seems most profitable. And really what we mean by that is that we can bring to bear additional services if there's a change in their current status. And that way we can maybe avoid additional problems, or we can kind of providing additional treatment as needed. And then, if we can get the appropriate community-based treatment and the appropriate community supports with good housing is really going to be the greatest likelihood of success. And my last slide is really the most important. I told her I was going to do this last night, but you can address any kind of questions or any sort of complaints, especially to Gina Meir at Tulane University. She'll be expecting your complaints. So feel free to send them all her way. And I think we're open for questions with a few minutes to spare even.
Thank you so much. We already have a handful of questions.
Oh, good, thanks.
And forgive me, I'm having to work off my cell phone today.
That's fine, Julie, we'll make it work.
All right. Do you ever run across or use vocational rehabilitation services with NGRI acquittees upon release back into the community? This individual anecdotally feels this is an underutilized mode of care and support for any individual reintegrating into communities.
Yeah, I haven't done that personally, but I could not agree with that comment more. I think, if the more we can provide our individuals with these chances at successful reintegration through vocational rehabilitation and vocational services like that, in addition, right, it's getting back to that R&R model, but in addition to all the other mental health services that they need, I think we're putting them in the best possible position for success. And any sort of program that does that. And often I think community support programs will do that. So I think they're embedded in some programs, but anything additional to that, you're not going to hear an argument from me, because I think what we want to do is put our folks in the best position possible. And we all value work. So, they would be no different. So as part of that independence and establishing all those things. But if there was additional service brought in addition to what the state is doing, I think that's a very, very effective way to do things. So absolutely, that's an A+ idea.
Mm-hmm. Next individual says you've talked comprehensively about approaching CR evaluations, but you've made it clear that the lack of a systemic approach to such evaluations is a problem. Are you aware of any such instruments in development?
No. Many years ago, Neil Gowan-Smith and I talked about doing the conditional release assessment protocol. That would be crap for those. Be quick, but we haven't gone any further than that. That was a joke, by the way. But we talked about it. The HR 20, especially version 3. If you look at the Minnesota data, the version 3 works very, very well, especially with its consideration of both factors that are present, but also factors that are relevant for these individuals. But I think we could probably develop a measure that would have a ROC of about 0.80, which I think if you look at the risk assessment data, that's kind of what you get with everything. But I don't think there's anything in development. I think the important thing is to look at those individual factors. in addition, which the HCR 20 encourages. So you do your standardized assessment, but then you look at what this individual needs. What are these particular individual factors? Does this individual have a specific strength that we can maybe utilize in the community to keep them out? And I do think, and if I had like a full day seminar, we talk a lot more about protective factors, which I almost never see in forensic reports on violence risk. But protective factors are things that we should be integrating within our individuals, because we can really sort of use these factors to sort of and to help guide us develop appropriate services for them. So I think there's ways to do it, but I think there's nothing specific. But I do think we need to consider protective factors as well, and then balance those out.
For everyone that needs to jump off, we are right at the hour. We are going to keep asking, doing some questions, but make sure you grab that survey link if you've got to jump off. Next question: are conditional release plans public information?
I don't know. It's a really good question. I think generally no, but again, if you went to the court and asked them for that, or if you filed a public information request, I don't know. That's very fair. I have no idea. Good question.
Next question: in order for a defendant to be adjudicated NGRI, they must be considered competent to stand trial and are therefore often psychiatrically stable. Are you aware of many states, or any states, that allow for release to the community for acquittees who do not meet criteria for hospitalization?
Yeah, I just mentioned in my talk, both Virginia and Wisconsin allow for that. And also we did some basic, just some real simple results and analysis on that, found that they do as well as other folks there. So it seems that once you kind of get stable and you have the appropriate plan, at least in Virginia and Wisconsin, those folks do very well. And my guess is there's other states that allow that as well. But those two I know about and have looked at the data myself on that, and I know that goes very well. So yes, that is allowed. By the way, I just went to a talk in Germany from somebody from Sweden, and they don't have competency or insanity. Anybody with a mental health issue gets evaluated, and they either go to the hospital or go to prison. It's a much different way of doing things. I just found that fascinating.
Next question: most inpatient facilities will require recommended violence risk assessment in advance of granting a committed patient conditional release or increase in privileges. However, as independent access to the community increases, so too does the opportunity to abscond from the hospital. How would you recommend assessing, mitigating, or conceptualizing the risk of elopement or unauthorized leave?
Probably what I'm going to say here is not a popular opinion, because we often don't look at that, but in those factors, at least in my experience, and there was a study by Carl Giacono many years ago that talks about psychopathy as a risk factor for these things. And I actually believe this. I think individuals who have higher level of psychopathic traits are much more likely to abscond than individuals with low level. The other thing I would really think about here is a deep dive into someone's history. Do they have a history of escape? Kind of what are those circumstances? If so, I would be very cautious with those folks. And I'm not saying not grant the privileges, but I think those are a couple of factors that I would be very mindful of when kind of considering these. But those are tough. Those are always tough decisions, because we don't have specific risk assessment instruments that actually look at like escape per se.
And this next question is in line a little bit with the answer you just provided, but any thoughts on NGRI patients who present with inherent risk secondary to personality disorders and whose risk is not necessarily mitigated by medication or as effectively by therapy?
And that's a great question. And again, that's jurisdictionally very different. Some states, and through their case law, have actually indicated that individuals with personality disorders still indicate that they have a continuing mental illness. Some do not. So, you know, it's very different. And often we also have seen, and I've certainly seen this enough, that as individuals kind of become, as their psychosis remits, some of those longstanding personality factors kind of come to the forefront that maybe were hidden based on disorganization or various things. But those individuals, I would agree, are the highest level of challenges and likely the highest level of risk. And some states, by the way, based on, again, on how states have their state legislators have interpreted various things, will allow continued mental health treatment based on dangerousness alone following an NGRI. But again, that's very, very different depending on your jurisdiction. There's a whole lot of caveats that we don't have enough time today to kind of wade through.
Is the critical period or the highest risk for problems after hospital release of forensic individuals about the same as that as civil folks, as mentioned in the MacArthur study?
Yeah, it seems to be. It seems to be that there's the earlier in after release, the more at risk that they are. But the data on that isn't great. And again, it depends what your idea of risk is and how you're compensating risk. I think MacArthur's study only looked at violence primarily. But I think there's an initial period in there that people seem to be more at risk anyway, at least for coming back. But of course, it also might be kind of complicated by the fact that they're upon an initial discharge, there might be a higher level of supervision there. Mm-hmm. So again, these are factors that are really hard to measure and hard to kind of get to. But I think the bottom line is that yes, it's a long way of getting there.
Given the variability you've mentioned across states regarding the NGRI determination process and conditional release readiness evaluations, do you think it'd be helpful to have a federal level regulated standard method of practice?
That's a political legal question. I mean, I think Canada does that. You know, what's great about that is their data is all in one place and easy to get to, and they do terrific work. I don't think that will. I think it's almost a moot point here because there's 4 states that Supreme Court just said last year, you know, can have almost no insanity defense, and so I can't imagine that would ever fly here based on state rights. So it's almost a non-existent point. Yeah, would it be helpful? Certainly.
Let's see here. What do you think about inmates who will be most appropriate for community-based psychiatric care but are refusing psychotropic medication while they're incarcerated? What's the best recommended intervention and treatment plan in that type of case? No idea. I mean, if they use the word inmate, so is that I assume that's a correctional facility. And again, laws are different if they're based on dangerousness, civil commitment. If they meant insanity, acquittee, those folks probably aren't getting out. So I don't really know how to answer that. Next question is, you discussed the HCR at length, but what are your thoughts on also using actuarial measures such as the VRAG? Yeah, I absolutely, you know, again, now it depends on your facility, but I absolutely like the VRAG. And in fact, when I have more time to work with the case, I love some of the treatment scales on the MMPI. Like there's various treatment scales that I think really are very, very helpful to sort of conceptualizing this whole thing. But I think the VRAG presents a very, very nice sort of baseline level of where someone is at. But I think if you do that alone, I think you're really missing the fact that it's the dynamic variables that seem to be the most important. But I do like the VRAG and I use it frequently. And I think it's in its 2nd edition now. Mm-hmm. Yeah, so I'm a big fan. Next person says that their state is one of the very few that discharges almost all insanity acquittees from their hospital commitment unconditionally. And while there is a comprehensive discharge plan, there's no system of monitoring compliance or revoking release. What recommendations would you have for treatment providers preparing these acquittees for unconditional release and for evaluators who make discharge decisions? Wow, that's an entire hour
hour seminar. I don't know. I would really kind of focus on some of these models of release and how they best work with your folks. And if they're going straight from the hospital to non-supervision, I mean, personally, it might change the way I conceptualize violence risk, given the fact that they're not going to be monitored. So that would seem to be a little bit concerning to me. But that's interesting. You could write me later, tell me more about that. I'm very interested in that. I probably have time for about 2 questions left, Julie, before I got to roll. But
We're actually
are we done?
About 10 minutes after to give everyone a chance to get
Awesome.
to where they go. So thank you so much. We really, really
great.
And I'll be in touch.
Thanks, Julie. Great seeing you guys. Thanks, everybody. Have a great day.
Take care. Bye-bye.
Bye-bye. Thanks, Alex.
Thanks, Mike. Good to see you.
Good to see you, man. Take care.
You too.